Welcome to the trial. Welcome. What's up, everybody? It's YNW Melly. Let me do a check here, make sure we're got good audio, video, all that good ish. Are we live? Okay, we are live. Is the audio good? Okay, good. Sounded really low. Let me do a check here, make sure we're. Looks like it should be louder. Oh, is that me? Is it me? What's up? Good morning, man. Welcome. So we're gonna be doing day 4 today, and we're kind of doing like a trial and error run type of thing. I don't know if that's really what it should be called, but we're gonna be watching day 4. My throat's still being a little funny. I don't know, but I took some meds. I got some tea. I had to buy some tea and some stuff. So. But yeah, day 4 is supposed to be really good, and it's supposed to be whatever. The reason these people are calling a mistrial. So I don't think they start until like. Let's see. Pigs, 13 months, amazing. I'm already feeling I'm gonna need my cough drops. Hope you had an amazing Father's Day. It can mail and chat. Thank you, Diggs. 13 months. Hey. Day 4 is spicy. Okay, I'm hoping for it. Airborne gummies. Oh, you know what? Forgot how those. Too. Okay. We're here, and we're. Thank you, Shambot. Let me fast forward a little bit. Let's see where Mo said.
You were indicating that these social media are all from the defendant's account or something like that? Where are they from?
These are from the defendant's Snapchat account. Here on it. And so I'll have it marked as.
It was 53 minutes in. 53 minutes. Want to start from 53. The legal battle and issue started at 53:21. Okay.
Curious. Tell me what your other issue is.
Ready to.
No, tell me what the issue is.
The issue is we got presented this morning with a host of chat downloads that were purportedly downloaded from the chat account of whom the state purports to be Mr. Demons' chat account. Before she introduces any statements, I think she needs to establish the relevance of them. This is just a download of a series of conversations, and putting them in en masse is a problem.
Hey, me. I've been meaning to call you.
Putting them in individually would require her to establish the relevance of the particular statement she seeks to introduce before introducing it. Our initial review of the contents that she wants to introduce, shows relevancy problems, shows authentication problems, and shows prejudice and hearsay problems. So that's what we wanted to address before. We have a copy of what we're presenting here, and maybe we could present it to the court so you can take a look.
I haven't seen it taken a look at it. When do you anticipate presenting it?
Shortly after the first witness, but it's a business record on that. This is, and just so it's clear, this was provided as the initial discovery exhibit that was presented to defense counsel at the initial first ever discovery filing, and that was the it was on the exact date on that, but I believe that was approximately March of 2019.
So let me ask you this. I haven't seen it. How many exhibits are there? How many are there?
This one is not particularly voluminous. There's a handful of pages, and then there are some video clips and some images. With regards to the images, I brought that to defense counsel's attention because there is one image that is on the defendant's Snapchat account that references some of the more inflammatory song titles. So I was going to tell them I'd be happy to hide that file so that the jury would not be able to access that or see that.
Okay.
And so I can provide those to Your Honor in the printout.
Sure. Has it been marked for identification?
It has not yet.
So why don't we have it marked?
By the way, anybody that watches or has watched Black Mirror, they came out with a new season last night, or not last night, this month I think it came out. I just noticed last night, so I watched one episode. Pretty interesting.
Identification. And is it possible that you do this or introduce these after lunch so we have a chance to look at them?
No, Your Honor. That's not for time frame on that. Like I said, I indicated yesterday due to one of the witnesses having COVID, we would probably have to end early
Who got COVID?
this afternoon, and I beg your indulgence on the time and the schedule on that.
So there's an objection. I need to review it and see what it says. So after, who's the next witness? Yeah.
Tara Kelso, the RJ Lee.
So we'll talk about it after. Just have it marked as an exhibit, and if you could, just give a copy to Travis after it's been marked, and I'll see if I can take a look at it as we're going. All right?
No.
Okay.
But you said there's videos as well?
Yes, Your Honor. So there are
You're
videos.
objecting to these videos?
On relevance grounds and authentication.
You know, when we take a break, I'll look, you just play it, we'll see what they're,
They're relatively short on the videos. So.
all right?
Okay.
And you were indicating that these social media are all from the defendant's account or something like that? Where are they from?
These are from the defendant's Snapchat account, Your Honor. And so I'll have it marked as states triple.
So they're trying to, I mean, from what I'm gathering, I don't know, because we've been jumping around. They're trying to bring into the Snapchat stuff. And I don't know if they're trying to figure out. I should try to pull it up and see if they talked about it.
J for identification purposes, presenting to Travis a copy of the business records, authentication and certification, a copy of the printout of the chat.
They're saying it's irrelevant. There's snippets. I don't want to skip though to it. Snapchat. Judge denies prosecutions. Oh, request to use the Snap. Okay, so the Snapchat was like a problem. If you guys could hit like, I'd appreciate it, man. Thank you guys so much for joining. And we're just kind of, when I said trial and error, I'm meaning that we're catching up now. Tomorrow we'll be caught up, and we'll see if there's an interest. There is an interest in the story. I don't know if there's interest on this channel particularly, but right now we're covering old stuff that the people that have been watching have seen already. So we'll have to see what happens Tuesday. And I was thinking we'll try it throughout the rest of the week and see what happens if we build up people or not. You know, if there's no interest, then we'll think about what we're gonna do next week. Make a decision. But right now, I don't think this interjects with any of the cases coming up. So I figure we can jump in a little bit and do this. And next weekend, I'd like to talk a little bit about that Corey thing too. Richens, I think, whatever. We'll see how things go.
Records that are in a table format. Everything is contained on a USB. I'm also presenting a printout of all of the photos that were associated with the account, as well as a copy of with the photo that could be potentially an issue, the name of the songs taken out, and a copy, a printout of the first part of the first initial clip or the initial frame of every one of the videos on there.
And you intend to play all of these videos to the jury?
Yes, Your Honor, because the defense is contesting whose account that is and whose phone was using this, so that's the state's initial relevance argument.
Thank you. And it's all the same Snapchat account?
It is.
Thank you.
Your Honor, as an initial, just so that you know, a Snapchat account, I'm not sure how familiar you are with social media, but a Snapchat account does not identify a device because it could be accessed from your computer. So I don't think that would be relevant to them.
They're talking about Melly Snapchat, the defendant.
Thank you. Let's bring the jury in.
Okay, so first witness starting at 101. So we'll do the first witness to the ex mom's, your ex-girlfriend's mom comes on, I think, at 3:12. But there's another witness before that, I guess.
Once again, reflect your ladies and gentlemen. I hope you have a nice evening, and I think we're ready to proceed. Madam State, you want to call your next witness, please?
Yes, Your Honor. The state calls Tara Helsel.
You raise your right hand, please, sworn.
Do you solemnly swear or affirm that the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Tara Helsel.
Please spell your first and last name for the court reporter.
Tarah, last name Helsel.
Thank you.
Please have a seat.
Hey.
Also, the microphone in front of you, who's up or down, doesn't go back and forth.
Okay.
Ready?
Yep.
Counsel, you're ready to proceed.
Thank you. Good morning.
Good morning.
Can you introduce yourself to the jury and tell them where you're currently employed?
Yes, my name is Tara Helsel, and I work at RJ Lee Group.
And in what capacity do you work at?
I am a forensic scientist and the manager of the forensics department
How long have you been employed by RG Lee?
since November of 2016.
Can you give the jury a background into your education?
Yes, I have a Bachelor of Science degree in forensic science from Waynesburg University.
And how about some of your training and certifications?
Sure. So I had to complete RJ Lee Group's training program for gunshot residue analysis. And this was a several month-long process that involved reading and learning the standard operating procedures, reading relevant publications about gunshot residue. I had to complete the analysis of 250 case samples, of which my results were compared to that of a trained analyst.
Oh, Amy.
I had to receive training on the scanning electron microscope, which is the instrument that we use for our analysis. I also had to take a test about that instrument, a test about gunshot residue overall, and then following all of that, I also had to take a competency exam.
Okay. And can you tell us, you mentioned that you also supervise?
Yes, I'm the manager of the department as well.
So how many individuals do you supervise?
Right now, just one.
And so you're responsible for overseeing their work as well?
Yes, absolutely.
And how many times have you ever testified in court regarding the area of GSR?
84 previous times.
And in the state of Florida
Yes, I believe 13 of those were in Florida.
and other states as well?
Yes, I've testified in 20 different states as well as
The mistrial thing, it has to do with, from what I'm reading, it has to do with the ex-girlfriend's mom. So I haven't watched that yet. Probably the people that are here probably haven't watched. I know there's people that have watched it. I haven't watched it. So I don't want to read too much into it because I want to see what actually happens real time. And then we're going to go into it. But it has something to do with the ex-girlfriend's mom.
Puerto Rico, Bermuda, and Turks and Caicos.
Has your entire professional career in the
Thank you,
area
Amy.
of GSR been with RJ Lee?
Yes, it has been.
Okay. Can you explain to the jury what is gunshot residue, commonly referred to as GSR?
Yes, so gunshot residue in the broadest sense of the term is referring to all of the particles that result from the discharging of a firearm. However, when I am talking about gunshot residue, I am referring specifically to the particles that come from the primer, which is one of the parts of the cartridge.
Okay. And what is the primer? And you can give us kind of a summary because you did hear from an expert yesterday regarding this.
Sure. So when you're thinking about a cartridge, it has the projectile or the bullet in it. It has gunpowder. And then at the bottom of the cartridge is something called the primer cap. And inside of there is a mixture called the primer. And that contains a couple of different compounds that together contain the metals of lead, barium, and antimony.
So lead, barium, and antimony.
Yes.
Okay, we'll remember those three. So how is it that gunshot residue is produced and deposited in a manner in which we then analyze?
So whenever a firearm is discharged and the trigger is pulled, this causes something inside of the firearm called the firing pin to strike the primer cap. So it'll hit the bottom of that cartridge and this will start a reaction. So this will cause the primer to burn, and the burning of the primer causes the gunpowder to burn. So as the gunpowder burns, there is a buildup of high heat and as a result, high pressure inside of the firearm. And that buildup of pressure is what ultimately will expel the bullet from the firearm. But
In her mouth. I wonder if that's the video itself. I do see you're talking about the audio sync. It does seem off. Maybe.
of that buildup of heat, those different elements I mentioned, such as the lead, barium, and antimony, are also going to heat up and become a gas. And this gas will exit the firearm through any available openings in the form of a vaporous cloud called a plume. So you have this gas exit the firearm, and it's now much fuller outside of the firearm than it was inside of the firearm. So those different metals will cool down and combine together and form particles. And those particles will land on the area surrounding the discharge, and those are the particles that I am looking for in my analysis.
And in general, how far is that gas traveling?
It depends on the environmental conditions. Things like weather and airflow can play a role, but in static conditions, typically about 4 to 6 feet.
Okay, and you mentioned the particles. What are the particles that are being produced by the discharge that you're looking for?
So there are 3 different types of primer-related particles. So the first are called particles characteristic of gunshot residue. And these would be particles that have lead, barium, and antimony all together in one particle. So these are considered characteristic because there are very few other sources of these particles aside from the discharge of a firearm. And it is the presence of those that we need to have to be able to call a sample positive for gunshot residue. There are also what are called 2-component particles, which would be any particle that contains 2 of those 3 metals. So it could be lead and barium, or lead and antimony, or barium and antimony. And these 2-component
And I believe it's, I guess it's law and crime. I guess they have a sync. It's out of sync with them. I know we've had the sync thing here before on the channel, but I was asking Mo about it. I think everybody that's used the video has this the sync thing.
particles also can come from the discharge of a firearm.
Rachel, good morning.
But there are other sources of them. So when they're found by themselves, they're not as conclusive to the presence of gunshot residue because they could have come from something else. But if they're found in combination with particles characteristic of gunshot residue, they're more likely to be from the discharge of a firearm and are kind of acting as part of that GSR population. And there is a third type of particle, which is just a one component particle, which would be lead by itself, barium by itself, or antimony by itself. And these also come from the discharge of a firearm, but there are even more other sources of those particles to where they're not very conclusive to the presence of gunshot residue. So we, our Lee group, do not report on those. We are just reporting on the characteristic particles and the two component particles.
And that's because, for instance, lead can be found in paint.
Yes, absolutely.
So the presence of lead in and of itself isn't indicative of GSR.
Exactly.
GSR.
And can you describe for us how you perform the analysis? And I know you brought up the microscope, which was briefly mentioned yesterday. Can you describe for us how that microscope works and your process?
Yes, so we use an instrument called the scanning electron microscope, which is also referred to as the SEM for short. So this is a very powerful microscope and it is computer controlled. So instead of looking at your samples through an eyepiece like you would in a traditional microscope, you're actually looking at them on a computer screen. And this instrument has the ability to magnify by thousands of times. And it also allows you to see the chemical composition of what you are looking at. So because gunshot residue is extremely small and not visible to the naked eye and is made of very specific elements, that's why we use the SEM. And the way our analysis actually works with it is two parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample folder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged.
Bro, I feel like I'm almost tripping out because Mo was telling me, like, did I rewind the thing? And I'm like, I don't think so. Sometimes that happens by accident. It feels like she's saying the same thing over and over. I feel like I'm tripping out. And then I looked at the timestamp. That shit looked like it's been almost in the same spot. I'm like, damn, am I tripping out? No, but she's...
And I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right? The SEM for short.
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes. So basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative aid assist you in your testimony to the jury as far as what the SEM shows?
Yes.
Again, ladies and gentlemen, the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony.
I almost just wanted to skip towards these.
Remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered by you as evidence in the case unless it's later received in evidence, and you should not use it as a substitute for evidence. Only items that are actually in evidence will go back with you to the jury room during your deliberations. You may proceed, counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here.
Cato said that a sack chaser threatened Melly's mom with a gun, and she responded on social media saying she had big guns. Next thing you know, the two were murdered by Melly, allegedly. Ooh.
With the top left.
Yes, so the top left is an image.
And we saw something over the, I forgot what day it was. It's all a blur now. We were chilling on Discord and we were talking about, allegedly there was something about the ex-girlfriend. I forgot which guy in the group had sent her pictures of his D. Allegedly, there was some sort of it was documented. It was some in the deposition. I think the ex-girlfriend's mother had said that her daughter had told her. I don't know if it was sack chaser or I forgot. Maybe you guys have been following this case will know. I might cover that at some point too.
Showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right.
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left.
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So
Sack chaser? Ooh,
is lead.
that's interesting. I wonder if that stuff is true because then we got the whole thing of sack chaser sending D pics allegedly to the girlfriend at the time, and then also allegedly sack chaser threatened Melly's mom with a gun. Yeah, that's his nickname, sack chaser.
BA is barium, and
Oh, I forgot.
SV is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, approaching defense counsel has been previously marked the state's LLL for identification purposes.
Oh, let me do cheeks. I already forgot cheeks. I'm so ADD. All right.
Your Honor, permission to approach the witness.
You may.
And if you said you handle anything biological, there are gloves right there, and the top has been open for ease of access. Tell me if you recognize it first, and if you need to open it, if you can just keep it outside the view of the jury.
I do recognize it.
And how is it that you recognize it?
This is one of the items that I received. in
Two
this
types of
particular
Zach.
case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of a Jeep.
Okay, and is that in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state would move into evidence because pre-marked the state's LLL as the next number exhibit.
No objection. Thank you. It'll be admitted. What's the next number?
60.
Oh, the friend gets
60 in evidence. Thank you.
Patty says, "Do you think he did it, Mel?" I don't know. I mean, I'm just getting into this case now. I think it's possible. I want to wait and see what else they have to say. This is just like the very, very beginning of the trial. This is day 4. Tomorrow we'll be caught up day 5. And a lot of the times during the trials, they have like these moments, what us might consider boring or slow. they have to go through all this forensic stuff and all that. But then there's, I mean, the Letitia Stalk trial was really nonstop interesting, back to back every day. There was I think one day where there was like kind of like Johnny Depp was good too, but even Johnny Depp had its moments where it's kind of like slow and stuff. But Johnny Depp was like really, really funny, really good trial. This one has, I think, a lot of potential. I mean, I've seen some of the clips blowing up and going viral, so I think it's starting to get interesting. But do I think it did it? I don't know. Maybe, likely, probably likely. I mean, I don't know who else did it, right? I mean, because what side did the bullets come in from? They claim the bullets come in from, right? Because if they believe it's a drive-by shooting, so they for the two of them on the right side to get hit, and the people on the left, the driver, which I forgot his name, the driver, I had the name somewhere, and then Melly sitting behind the driver, Cardinal, whatever his name is, right? The driver and Melly sitting behind him. If it was a drive-by shooting, it couldn't come from the left, so they would have to claim it came from the right. And I just wonder about like the trajectory and stuff, because would those bullets have gone through them and hit the other people, like Melly and the other driver? I mean, sometimes bullets can bounce inside of you, depending on what kind of, I guess the caliber, I'm not sure. Left cheek, that's what Melly said. Left? Really? Murdoch. Well, yeah, Melly claims he wasn't in the car. He claimed that they met up and at some point he got into the red car, the red vehicle. The back window was shot out, but it's amazing how everyone on the driver's side was spared, right? After a drive-by, they didn't go. You're right. Cato said after a drive-by, you go right to the hospital. They drove around for 15 minutes. Damn. Sled.
Looking for 57.
This is a gun.
57, do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you
I think it's
also
back in sync.
analyze state 60?
Yes, I did.
Okay. So, grab your scissors. 57. And grab some gloves and we'll.
So that's the driver, right? Cortland Henry.
So you received one sample, but there are two tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
And you can put those back in. And if you can publish states 60. And we have one tube, and what is that representative of?
It is labeled as coming from inside of a Jeep.
If you believe it, it will adjust. Thank you. You can put it back in and take your seat.
The thing is, like, I think they're calling this a circumstantial case so far, right? And with death, the death penalty on the line, that's the only thing that kind of like. Are they going to send him to death? Like, it feels like the burden of proof would almost be higher, I would think, no? Or like the knowing that the death penalty is on the line. Maybe these people will think extra about sending somebody to death. Circumstantial evidence battle ensues. First week.
Okay, we're going to start with case 57. Did you ultimately have a chance to analyze and go through this SEM process, which was the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and two component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all 3 components.
Yes.
Okay, and let's move on to stage 60, which was the sample for the Jeep. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay, and what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, oftentimes if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
And I want to ask you about presumptive tests. Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, you to confirm?
Yes.
Nothing further.
Councilor Zane Cross,
Yes,
you're ready to proceed.
thank you. Good morning.
Good morning.
I don't think we've had an opportunity to meet with you.
No.
You got the sample from Miramar Police Department,
Yes.
specifically Detective Moretti directed it to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, calls for speculation outside the scope of the court.
Well, I know that calls
Reminded me of the Murdoch stuff a little bit.
for speculation. She knows she can answer the question. Overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
But if in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Could I have one moment?
Yes, sir.
Thank you very much.
Thank you.
Matt Murdoch.
Any redirect?
Yes, Your Honor. Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered,
If it's removed?
yes, any activity can cause particles to be disrupted or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question, if I
Yes.
may. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
Thank you.
Anything else?
No, Your Honor, nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you very much, ma'am. Can you step down your excuse? Thank you. Can I see sidewalk, please?
So,
Let the record reflect the juror stepped out, Counselor Maine. I have, and this has been marked as states JJJ, triple J, and it's a Snapchat account. And so, what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Jamel Demmons. They are conversations and statements that he makes, some of which reference this homicide and Portland Henry. And there's some specific comments from Mr. Demmons to an individual that's identified by a Snapchat name, and it's on there, DHAT is what it starts with, in which he says that Portland Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that is why it's necessary to show that all of the photos and videos in that particular item are of Jamel Demmons. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as
No, they didn't.
Hamilton.
Baby girl said Florida is desperate after Thursday's court. Yesterday, they released a video of Melly snitching in another shooting years ago. What shooting is that? Because Cheeks had sent me an article about this Vero Beach shooting of this officer. And I had been told that they believe that these guys were involved, Melly and Cortland. You want to stop for a second? Read this article. Let's do this real quick. I want to see what this is about. This is from 2017. Let's do this. Let's jump on this for a second. I'm a little. Just bear with me. I'm on meds. Cold man. I got the Mucinex liquid. I chugged that. Took some tea. And I'm going to be cruising. All right, let's see. So, shooting death of deputy remains unsolved. I've been to Vero before. I had the Pink Justice. Those girls, they live out there. I met them out there, and then we went up North Florida before. Today marks the 5-year anniversary of the shooting death of off-duty sheriff's deputy Gary Chambliss, who was visiting family in his Gifford neighborhood when struck by a stray bullet fired during a dispute 200 feet from where he was standing. That is crazy. Imagine being killed like that. I mean, I guess that happens frequently, but like you're just standing somewhere else, just doing your own thing. One stray bullet, and your life is over. Apparently detectives from law enforcement agency he served for more than 27 years are no closer to arresting the shooter than they were that ill-fated Friday night, 4 days after Chambliss' 50th birthday. If they had made progress in their investigation, they were not telling anyone, not even the Chambliss family. I don't know what's going on, Chambliss' daughter, Brianna, said during a phone interview last week, adding that last update on the investigation she received was from former sheriff Daryl Loar, shortly before he left office in January 2021. He would keep in touch, check on us to make sure we were okay, and told me the detective who was working in the case had retired. Damn. She continued, that was over a year ago, and I haven't heard anything. Loar's successor apparently hasn't been accommodating. Brianna said that she hasn't met with Sheriff Eric Flowers or his detectives to discuss the status of the agency's investigation, despite seeing Flowers at the Indian River County Victim Rights Coalition annual candlelight vigil at the courthouse in December. She said Flowers told her one of the detectives would call, and she's still waiting. Damn, so they just snubbed her. Aren't they supposed to look out for each other, one of their own, and look out for the family to make sure the family's taken care of? They just left her high and dry. It's been 5 years, she added, and there's not a week or even a day that goes by that I don't think about him and what happened. Brianna says she plans to call the sheriff's office and speak with detectives handling the case. Vero Beach 32963 attempted to do the same multiple times over the past 2 weeks, hoping to provide readers with an update on the status of the investigation, but the detectives declined to be interviewed. Sheriff's Office spokesperson Debbie said detectives needed to go through the file and determine what information can be released without jeopardizing the investigation. She said the agency also was planning to honor Gary Chambliss with a remembrance, but no details were available. Brianna said that she had not been notified of any such plans. She's more concerned, though, with seeing the sheriff's office bring her father's killer to justice. She said she's surprised the case hasn't already been solved, given her father was a longtime deputy and the urgency law enforcement agencies usually place on apprehending cop killers. They just let this shit slide. I mean, I'm saying I don't know if that's true, but it seems like that. I'd feel like that if that was my father. I'd be pissed. It makes me sad to see that the shooter is still out there, Brianna said. It makes me angry too because everyone believes that this was done by someone from my community, so I could be walking around with someone who killed my dad. It could be someone I see all the time. The night sky had arrived on February 17, 2017, when gunfire erupted between the 4300 and 4400 blocks of 28th Avenue, where groups of people were gathered after a wake at the Mount Sinai Missionary Baptist Church. According to the sheriff's office report, a bottle was thrown out of a passing car, and the driver responded by firing gunshots, which prompted at least one person in the groups to return fire. Gary, known in the community as Kool-Aid because of his infectious smile, was standing near the road, and upon hearing the gunshots, yelled for people to get down before he was fatally struck by one of the bullets. Hours later, deputies arrested 21-year-old Mikhail Chambliss, who was a distant relative of the deceased, and charged him with discharging a firearm from a vehicle, which is a felony under law. The bullets from his gun, however, did not match the caliber of the bullet that killed Gary. That is interesting. So they arrested his family member, a distant relative? Was he in the vehicle at all? Or was he in the vehicle and his firearm just didn't match? What? 3 years ago, sheriff's detectives investigating the case drove to the Broward County Jail to question two Vero Beach connected rap musicians, with two high-ranking law enforcement sources said were at the scene of the shooting. So they questioned two Vero Beach connected rap musicians who two high-ranking law enforcement sources said were at the source of the shooting or scene of the shooting. Detectives believe one of the rappers might have fired the fatal shot, sources said, but the sheriff's office never confirmed the rappers were suspects or even persons of interest in the case. Okay, so we don't know. It's alleged that they were at the scene. Jamel Demons Melly and Cortland Henry, also known as Bortland. Oh, that's why he really did change his name to B for their rap name, YNW Bortland, because they got to change the C's to B's. Both indicted by a Broward County grand jury on 2 counts of first-degree murder in connection with the deaths of 2 friends, Christopher and Anthony. If convicted, they could face a death penalty. The detectives thought it might have been the rappers, but that was 3 years ago, Brianna said. I haven't heard much about them since. In October 2017, county officials honored the fallen deputy by naming 28th Avenue in Gifford between 41st and 45th Street Sheriff Deputy Gary Chambliss Avenue. Oh. I don't know. Okay. That's weird. It's odd. Broward County.
That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So regarding these videos, how long are they? How many? I mean, you sent me
Yes, that's
3 pages listed. I don't know how long these tapes would take a look at.
They're less than 30 seconds each approximately.
So let's put them in.
The drive bit is right there.
Or just angle that.
Yeah, that's fine now.
So they said GSR was found on the driver. We don't know about Millie. I guess not on Millie. I keep saying Millie, but it's Melly. I don't know. Millie.
But why don't you sit over there? Is it all right if you sit over there? Or you... They're good?
I think that might be good.
You can reposition yourself.
Yeah, I'm moving that way.
Maybe.
Thank you.
And feel free to do that throughout.
Thank
If
you.
there's something showing up on the screen and you think you want a better view of it, you're always welcome.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that. I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's, not his account from Snapchat. And I understand that, if that's the case, but my understanding is they're saying it's not relevant.
This is
So the jury's not there right now. They had him step out. Mind on my murder, murder on my mind, slang that iron catching feelings, for real, blue, Balenciagas, Mama Cry.
one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that. So.
Image of the defendant, an image of the defendant and Mariah Hamilton, image of the defendant,
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that,
correct? That's why the next witness would do that.
Oh, okay, so the witness is going to be
Thank you, Millie.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas.
It's all smiles and everything, huh? Man.
There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
That should.
And a lot of the times too, I spoke about it during the Murdaugh trial, when people try to make the case of like, oh, they were so happy, or right before the murder, or they knew each other since childhood. That shit never phases me. Because I remember with the Alex Murdaugh trial, they were like, oh, but that's his wife, and that's his son. And they were smiling a couple hours before. That shit means nothing to me. You don't know how every day we cover these people, family members killing each other, wiping out the whole entire family, doing all kinds of crazy shit to people they've known for their entire life. And somehow people still act surprised. But they're family. But then, and? Right? And? That's exactly more reason probably why it's people, it's a lot of times it's somebody you know, ain't it? I forgot what the statistics are. A lot of times somebody, I don't know why people are so like, yeah, no, hard to believe. No, it's likely. Very fucking likely. That's why I locked my doors. When I was living at my mom's house, I love my mother. I locked the door. I don't think she would ever do anything like that, but I locked the door. I'm sleeping with the door locked. Ain't nobody coming in there without me knowing. I'm dead ass. Dead ass. I sleep with the door locked right now. In case Maddie one day, I don't know. I love my daughter, but you never know. You don't know these kids, man. That's just locked.
That's 62. There is a body.
You don't know what these kids going through, especially when they get older and shit and they're in school. God knows if they're watching on video and stuff. These kids be killing because you don't let them go have a sleepover. You know?
Try VLC.
That was the LC. So.
Anybody can snap. Oh, and then with all the mental health stuff and all that going on, and drugs or whatever. Oh, the video games, right? These kids kill over video games. Wasn't that something recent? The kid, I think there was I thought there was a court case where this guy killed his mom and dad, a grown ass kid too. Like I think he was in his 20s or some shit. But I think they told him he can't play video games or something. The kid snapped. Take my Switch, I take your life. That's the kids music. I'm gonna find that story because there was that.
Yeah, I think it's that one. Sharon, I'll switch over to a different computer.
This might be the guy. Daniel Petrick is a convicted murderer in Wellington, Ohio. At the age of 16, he shot both of his parents after his father confiscated his copy of the video game Halo 3. His mother died, but his father managed to recover from a critical injury. Oh, I thought the father died. That's an old case, though. It's happened numerous times, though. You can find a couple of cases like that. I think it's happened numerous times. There's a 10-year-old, too. Accused of killing mom over video game. Let's see what this just says here. Well, they say he struggled with significant psychological issues. You just never know, man. I mean, I don't know. Fast forward. Okay, thank you, Britt. Oh, she's trying to get the audios over there?
Sorry.
So this was the day of the murder? Before the murders happened? Let's see. October.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the estate be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what my understanding. Well, go ahead.
Okay.
Right. All right, thanks for sharing that. They need the most important shit here. The most important shit here. Like, get right there, like, you know you come back. You be someone pick up on me.
So yeah,
Hey man, I'm 19, I done seen 750,000 each. I ordered it, it'll be a meal. Got me shit. It'll be a meal, I make sure. You put sad when you get out, dude. Put sad when you get off your ass, man. Yeah, get off your ass, man.
so I guess they're saying the judge ruled that this was irrelevant, or the defense was trying to, and then the defense was saying it was, and the judge ruled like that. Which, yeah, I mean, I guess, like I see you guys see in the chat, I still don't know what the relevancy is.
Hey, bro, don't be speaking on you, bro. You didn't do that. He didn't do that. I've been out here about your ass saying you did that.
Those are all the videos, Counsel?
Yes, Your Honor.
All right, so, Counsel, why don't you tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's triple J.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there.
Baby Girl says they wanted the ex-girlfriend's mother to establish that this was his Snapchat account and stuff like that. Okay.
That implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements are. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy of a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence. Saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in doesn't cut it. As far as authenticity is concerned, and that's our relevance objection, relevance must be established.
Well, in other news.
I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 9.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simonet v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication, and so there's an element of ambush. But nonetheless, in the Simonet case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerned some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange and the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
The Roy versus State. I can print it out if you
I'm reading it right now.
I'm not sure what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
It exists, I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly. I
No,
have.
you cited it right. 279, Southern 3rd, 238. All right, go ahead.
Okay, this is language I took from the case.
I don't doubt it.
Yes.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
Demons.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he'd reverse, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message it's communicating. No evidence that the texts were recovered from a phone, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video, or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicator's visually. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191 Southern 3rd 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding, the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio. Somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you, and I misspoke. There was one opinion, it's a PC affirmed on Benjamin v. State, or Benjamin D. Roy v. State, that you cited, 279 Southern 3rd, 238. It's a PC affirmed, there is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right, so yes, counsel, you want to be heard?
Yes, Your Honor, with regards to, and defense counsel already has the Lamb case, so I'll just provide a printed copy to Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proffered evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defense,
Money can get you a pretty good lawyer. I've said this a couple of times, so I'm not going to go deep into it, but just referencing it real quick. I was a juror on this case. James Layritz, DUI charge. This was back in 2010 in Fort Lauderdale. I remember I got selected for jury duty, and I went in, and I was kind of excited. I wanted to do it because I saw a lot of people making up things just to get out of it, not to have to do jury duty. But I had no idea I was going to be picked for a case that was going to be like a month long, and that was my first experience. I've never been back in court like that again as a juror, but it was quite the experience, and I saw what money can buy you. He had a pretty good lawyer. I mean, they questioned and brought up anything and referenced anything to get anything shut down. And so he was acquitted of DUI manslaughter, but I think he did get charged for DUI or something. Like the other person too that sadly got killed, they had alcohol in their system as well. It was a weird, kind of a weird case, but it was interesting deliberating. And at one point too, we even gave up. At one point, we're just like, because there was one lady on the that was a juror that she was just not budging. I think she wanted to acquit him of everything. I think that's what she was saying. And we were like, no, he had alcohol. It was DUI. At least give this guy DUI. I think she was trying to, so she wasn't budging. And at one point we just said, screw it. And we went to the judge and he was like, go back and try again. and that's when we finally got her like to come to our thing. I think that's how it happened. I don't remember too well, but
statements, they are relevant. They go to the issue at fact of whether or not he committed these 2 homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username.
ooh,
It's also important to
I didn't know that.
remember
Baby girl said Melly's lawyers are Boozie's lawyers that got him off of death row. Really?
the individual, that doesn't tie it to a specific device. It ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, Counsel?
Yes, Your Honor. There are statements there that, in the conversations, that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So, context for what?
Ooh.
He's having an argument, a discussion with somebody on October 3rd. If they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced.
Her hair really is on fleek, right? Look at compared to the other attorney there. Her hair here, which I got a little shine. That's like Garnier shine, right? Like Garnier or Herbal Essence shine. This one here, her thing is like glistening and shit, reflective. Has like a reflective shield or something. Wow.
Single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question at issue.
Thank you. I'm going to defer ruling out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demons, you need a restroom break?
Already got shampoo?
Yes. We're in for a restroom break. We'll be in recess. Thank you.
Wow. Hers the shiniest in the courtroom. Not that there's anything. I like Garnier or what? Not Fruit of the Loom. I was gonna say Fruit of the Loom. Garnier. What do they call it? Fruit something? Garnier. Or Fructis, whatever they call that shit. I like the smell of that. That Garnier one stuff smells good. Herbal Essence smells good. I don't have that in my bathroom right now. But. All right, so I guess we can skip now, right? Take a break.
Is that changing the business.
The gun is more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting it.
Okay, so what I'll do, with your next permission, is I will pull them up here and verify them. because then I'd be changing the business records on that.
A full bottle of conditioner each day.
Working with your honors roll.
So they're still trying to get stuff admitted. It does smell really good, right? Oh, I've been wanting to try that. The Sasquatch stuff.
So that maybe
That's for men, right?
videos in the bathroom.
I'll look it up.
Judge, with regards to this particular video,
I'm gonna order it.
the second video doesn't have the defendant's picture in it, so just so it's clear.
So I have extra shit, like, and the most important shit here.
And so, Your Honor, what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine. The gun should be out. It's not,
Your Honor,
it's saved before.
could she at least articulate the relevance of anything? I mean, I understand.
I heard your argument, I understand it.
Okay.
And I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is on 403 analysis saying that you can't, I don't see the relevance, I don't see the probative value of the gun and the cash being outweighed by overruled.
Defense counsel is also asking to take out the photo of the song and their titles or whichever else.
Right, I agree, take it out. Murder on my mind.
Uh-oh. They just want to bring the murder my mind shit in. Yeah, I covered the murder thing yesterday. The guy that murdered his 3 kids. We'll probably be following up on that.
5 minutes to fix that video.
Trying to fix this. I think over the weekend too, coming up, there's another case I want to cover a little bit, talk about it. This woman that killed the husband with fentanyl.
Visual images.
All right, we'll be in recess.
Oh, they're gonna take recess?
Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos and pictures, or
The judge's head's shiny
the
too?
court also decided that all the communications come in without the state asserting a relevancy objection as to each statement, or a relevancy as to each statement?
Counsel, the videos, my understanding, the videos as well as the written conversations, are you articulated and objected, saying they're not relevant and they can't be authenticated and things like that, and the objection is they can't be authenticated, we don't, because how Snapchat works, anybody could have done it, and counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts, it's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not, I'm making that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are irrelevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
Because there's a statement in there which there's the state believes is an admission.
Okay, well, if that is the case, then that statement should come in. And if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with a gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objections overruled. The authentication objection, I'd admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you, Judge.
Here, I may have a moment to show defense counsel the clip as it's been.
You go ahead, we're in recess for a minute.
Okay.
Show whatever you want to show.
All the other ones are already taken out. This is the other one to take out the gun.
Of these so-called videos on,
Yes, they are on each specific one.
could I see that diagram again?
Yes, it's there.
We're in recess.
Identifying what you think is a confession in there. Identifying. Hold on, we gotta hear that again. Can you at least identify what you think is a confession in there? Identifying. I don't understand why you would not identify, because then you might not have an objection to the rest.
But you probably still want to that.
Yeah, but then it would be invisible based on her theory. So are they talking about, because I saw somebody in the chat saying it earlier, that whole thing where he goes like, I did that, shh, whatever. Is Melly wealthy? Melly? Maybe. I don't know, wealthy. Gotta be rich. He has a lot of money. I don't know. How much does he? Let's see. I mean, yeah, that one song has 500 million views. That alone, whew. Let's see. 5 million, I think it says here on one website.
I'm not concerned about that. The judge said take him out.
Some websites say he's worth 5 million.
If you take him out, don't take him
3, 4, 5 million.
out. I don't need his.
No, it says 7.4. Let me fast forward.
No, you take the position that if you think there are confessions in there or statements that implicate him, identify them. This is the only one. This page.
On November
No,
9th.
Oh.
On November
You're
9th.
telling me what I'm saying. I'm saying.
What? Wait, what? Yo, wait, what? He put like the finger at her too, like. Oh, hold up. Okay. Let me turn that up a little bit for you guys. Don't tell me what I'm saying. Is that what he said? Don't tell me what I'm saying. What's that?
statements that implicate him, identified. This is the only one. This page. On November 9th. On November 9th. Telling me what I'm saying. I'm saying identify.
Did you just say that?
On November 9th. Telling me what I'm saying.
Oh shit! Don't tell me what I'm saying. He got like sass and shit. Don't tell me what I'm saying. Oh.
Saying identify what you want in. Because do you think it's all admissible to prove that it's his account? If we're not contesting that it's his account, then you're putting in an informed information. Identify what you want in so that we can make an informed decision. If you violate the judge's order, then it's a you problem.
Oh.
I don't need to review.
Oh. He said that's a you problem. No, you're not gonna tell me what I said. No. Don't tell me what I said. Shit.
Can you make these I know you gave it. Okay.
Yes.
Like a character. You a character.
Okay.
Villain.
I'm not trying to be difficult. I know you're bad.
Good cop, bad cop. He's the good cops in the back, and that's bad cop. Gotta do both strategies.
Problems.
Council's gonna take you a few minutes.
The video's done.
Well, those net worth things, he could probably have a lot more money. Those are just like estimates. Who knows? Sometimes those things don't even take into account, a lot of other things, sponsorships, whatever other situations he has going on. So it's just an estimate. He might very well have a lot more. I don't know. But that's just what the websites are saying.
They just said Allison is taking a pizza. And we just wanted to be clear that if we are,
So you want to be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and juror. Yes, sir.
The state is asserting that among the conversations in state's exhibit, what was it? Mark for identification. Triple J, that there are certain conversations or certain exchanges which she believes relate to facts at issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demons. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the court. Thank you.
Thank you. What says the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can you please consider, there's whole conversations with Ms. Mariah Hamilton that really, that goes to authenticate the who's count it is, but I don't know that
Negative
it does
5.
anything other than that. And can I see the exchange again, please? JJJ?
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
I apologize.
No, it's my fault, I accept responsibility. The report, I get 2 or 3 points off my guideline sentence.
We're getting closer to the ex-girlfriend's mother. This is where he's... I thought he was going to pray. He smiles a lot with him. Smiles and giggles a lot. Reminds me of the other attorney in the last trial that we watched, Letitia. He was really smiley, giggly. But I wonder if that... Is that really... I don't know. Is it genuine? Maybe she's genuine. Maybe she's smitten over him. Or is this just to keep their client happy? You know, have a little whatever, appease them, smile, keep them happy. You know, I wonder if that's a thing. I don't know.
So, attorney, jury room, I'm not fully understanding everything.
That's from earlier today. I don't know when that was. We saw it already, I think. I think that was yesterday.
Not objecting to the Snapchat conversations. You're not going to argue to the jury in some way, shape, or form that it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I am saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account.
Okay.
So that she can get our evidence in, but to get the rest in. Your Honor.
No problem. We just leave it the way it is.
We're clear. Okay. There may be another issue, not as though I have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B. And the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stand for that position. Dudley v. State, 545 Southern 2nd, 857, Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126, Florida 4th DCA, 2013. Curtis v. State, 876 Southern 2nd, 13, Southern 2nd, 13, and that's 1st DCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have first aid as well?
I do indeed.
Take a look, whatever you got.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes,
All right, so it is Ms. Holmes. And,
not Ms. Hamilton.
Felicia Holmes, sorry.
and what do you anticipate Ms. Holmes saying?
Judge, I believe she'll testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct Your Honor's attention to 90-803 subsection 5, past recollection recorded, in which a witness who no longer has a memory of an event but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 90-803 sub 5.
So you're telling me you've spoken with her, did a pre-trial discussion with her, and she said she has no memory of what she said at the time?
There are parts of which the statement she does not recall. That is correct.
May I retort?
Sure.
Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different, and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Okay, much more recent than that, no?
22. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject, is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forward,
that's true,
prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior inconsistent statement it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior inconsistent statement or an out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
But he's like warning them.
Thank you.
Giving them a warning.
Anything else, ma'am?
Just the record's clear in her deposition and counted. She says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 980305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of the 3.
And what's her statement, Councilman?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember, what you are going to try to refresh her recollection with?
So she says that she was woken up at 4 a.m. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Demmons then says he was saying that meaning Mr. Demmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Demmons, are you okay? His response was, I'm okay. She then asks him where are Sack and Juvie, the common nicknames of the 2 victims, and he said, I don't know if they're in the car, I think they're dead. So she then says, you think they're dead. She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Demmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Demmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then will says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Demons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The questions asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and her answer to that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember.
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent. In the Curtis case, 876 Southern 2nd 113, which is a First District case in 2004. This is the language. It says Florida allows litigants to impeach their own witnesses, that does not.
Thank you, Ann, so much for the super chat. Appreciate that. So we're almost up to the ex-girlfriend's mom, I think, right? It's like 3 hours. There she is. All right, so we're almost there. I'm glad, I guess, we watched most of this because it gives a bit of context. And the PDF that Mo found the other day, because we were sitting on Discord talking about it, and Samantha had actually told us about this. I didn't know about this deposition. The deposition's online, but it seems like they're arguing here that, like, she's saying she can't remember what she said back then, and the defense attorney is trying to say, well, it's your job to sit down with the witness and refresh them and prepare them. And so he's saying, like, so out of all the witnesses, this is the one you didn't sit down and prepare? So I haven't watched this yet. I heard this thing was kind of sus. Okay, ex-girlfriend's mama is kind of sus, but the ex-girlfriend, I don't have the stuff in front of me because I don't know where the PDF is. Mo's gonna send it to me when she has a chance. They had a FaceTime conversation, and supposedly also she claimed that, I think, Sack Chaser, I don't know if it was in this depo, she claimed that Sack Chaser sent D-pics to the girlfriend at the time. So I don't know, bro.
Necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the party's may justify the trial court's exercise of discretion in calling the witness as a court witness, call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling him. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State, 120 Southern 3rd, 126, 4th District, 2013, the language that we're relying on says, in Ruff v. State, 31, Southern 3rd, 833, Florida, 4th DCA, 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with the balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State, 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 a.m. concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation.
What do y'all think? Is she telling the truth though? I mean, I haven't seen this yet, but is ex-girlfriend's mom, is she telling the truth, or is she being a little fishy, a little sussy? You know what I'm saying? Or what? It is a long time ago, but I mean, but then why the prosecution didn't sit down? If that's what they normally do, which I guess makes sense, to sit them down and kind of refresh. And if this is such an important witness because she believes there's an admission of guilt, why wouldn't you have taken the time to sit down and really go over this shit? If it seems like it would be a really important witness to try to prove your case.
And it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation.
Was she paid off? They paid mama off? She's lying like a rug. Allegedly. Did allegedly ex-mama get paid off?
Notion that she is now just going to read the statement into evidence on some pretext.
Or she's just afraid.
Is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. And we object.
All right, anything else? Madam State?
No, Your Honor.
So we're gonna bring it in, we're gonna see where it goes. All right, I understand what the objection. God bless. I understand
That was somebody
what the-
sneezing. It sounded like a dog. So it was like a dog in the courtroom.
All right, anything else? Madam State?
No, Your Honor.
So we're gonna bring it in.
Oh,
we're
that's
gonna
the
see where it
attorney.
goes.
I didn't see that. This is the attorney over here in the corner.
All right, I understand what the objection.
I thought it was a dog
The
barking.
objection is.
Oh,
See
shit.
where it goes.
All right?
All right, let's bring the jury in.
Wow. Amazing. Okay, so now we get into it. Oh, what the hell is that? I was looking off my screen because I was renewing my antivirus thing. I just hear that barking. I mean, I was looking at a different window. You think, Jeanette? That's what. So Jeanette says, "I think the case is over tomorrow." I heard some people say that. I don't know, I'm kind of curious. I think tomorrow's going to be interesting when they come back in. Like I said, I haven't watched this yet, but I've heard that whatever happened, it was pretty bad, and of course they're requesting for a mistrial. So tomorrow when it starts, I think it's going to be pretty interesting.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Yeah, hold on.
put in through
Baby girl
this.
says, "Watch how she smiles at Melly when asked if she knows him." That tells you everything.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided a portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as being a phone that Mr. Demons used.
Correct. So, and if there are two first pages, because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just take the first page and the second page, or duplicates of one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated?
No. He knew and was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday I'm going to be locked up on, WTF, instead I just put third birthday, and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those, do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie King is on there. Then there's the phone number down here that's part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes, that are all listed on there.
And the state has not articulated a relevance of even.
And Barnes, thank you so much for the super chat earlier. Cat C, that was earlier as well. Thank you, Cat C. Selena, thank you for the 17-month membership. Selena 6, hello Mel, and the best chat on YouTube. Thank you. And Bees on Mars says I was finna cook, but y'all got me hooked. Are you in Florida? That's Florida talk. Finna. Or is that South talk? I like that's Florida talk.
Establishing Miss Holmes or Miss Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Miss Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there's several phone conversations there that do not involve the witness that they're about to call. And for those phone conversations to come in through that witness is just improper. How does she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
correct.
Does she know who the participants are? She's a party to this?
She is. She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever judgment you think are appropriate. Okay, so thank you. Sorry, something funny?
Pardon me?
Something funny?
Not at your ruling. Your Honor, I mean no disrespect to you. Right. And I hope you don't get that.
Oh! I was trying to see because they panned the camera away. I was like, who was smiling or laughing? I guess he's talking to the defense attorney. It's like, is something funny? There's something funny?
I'm sorry, something funny?
Oh, shit.
Pardon me?
Something funny?
Not at your ruling. Your Honor, I mean no disrespect to you. Right. And I hope you don't get that impression.
Let's bring the jury.
Thank you.
Oh, something funny? You can't mess with the judge too much. He's a fiery guy, but you can't fuck with the judge too much. I like that other voice, the whisper voice he got. Don't talk to me like that. Or what it said, Dick sent me the quote. I think he said, what did the guy say? You're telling me what I'm saying? I'm saying I identify. Some shit. I don't remember. I gotta hear it again. All right, let's get it going. I put a poll in the chat, by the way. Will there be a mistrial? 39% say yes. 61% say no. It takes a lot for a mistrial, Deja Vu says. There won't be one IMO. Lilac, thank you so much the other day for the cash app. If you're there in the chat, appreciate that. Hope you're doing good. Doing laundry? I gotta do laundry too. I got a stack of laundry like right in my hallway there. It's like overflowing. I keep saying I'm gonna do better. I should have just put some this morning in while I'm doing this.
Jury entry?
Laughing at me. Oh, shit, I'm about to judge. Imagine you had Letitia's judge. Forgot his name. That guy wouldn't play. He would have. Bubble said definitely going to be a mistrial. I'm commander right now.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his attorney, assistant state attorney, the jury. Ladies and gentlemen, I apologize for the delay. My fault. Anybody else, I apologize for that. In any event, I think we're ready to proceed. So, Madam State, want to call your next witness, please?
Here we go.
Call Felicia Holmes. And you're at this time the state offers state triple J, which was previously shown to defense. And your 9803.6 is a business record. And request
Any additional objections, counsel?
No additional objections, but objecting on the ground previously raised.
Thank you. To be admitted.
Thank you.
Stage triple J will be marked stage 61.
61?
61.
Thank you.
Counsel, where's your witness?
They were down the hall.
So I noticed that, right? He is like rocking a lot. Yeah, I wonder if he's nervous. I mean, his demeanor has been a lot of smiles and stuff, but I wonder if that's how he really feels. Is it really that confident, or is it just wants to give off that perception? But he is rocking a lot, right? As soon as this witness is coming.
With your permission, I send you a text message, Ryan?
Yes. Good morning. Are you Ms. Holmes?
Yes, I am.
Welcome.
Hello.
Come on up here. This is our witness stand. Ms. Holmes, when we get there, what I'd like you to do is remain standing. Raise your right hand and be sworn. You get the first down. Thank you. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
Felicia Ashe Holmes,
Please spell your first and last name for the court reporter.
FELICIA, HOLMZ.
Thank you.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth. It'll just up or down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you may proceed.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just,
Nervous?
you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start
Bruh.
and just talk about who
She says
you
she
are.
feels threatened. I thought she was gonna say like nervous, but she said she feels threatened. By who? She's gonna say she's there against her will? The prosecution or the alleged killer?
So, Ms. Holmes,
But they're
I
cool with
wanna
each other.
Start and just talk about
I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about.
And I wonder how you could gloss over that. I feel threatened. All right, so yeah, we're gonna start off. I mean, maybe she doesn't want to dig into it, but bro, that's a big ass. The jury's there. I feel threatened.
Who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
And this is the prosecution's witness, bruh. Shit.
My name is Story.
Right, I guess she got subpoenaed. Oh yeah, she did get subpoenaed, right? Because she actually, we talked about this on Discord, right? She was actually arrested because they were trying to subpoena her before, and she they forced her with a subpoena, and she got arrested for that previously, right? She got arrested because she was avoiding it or something like that. Ooh, so they forcing her ass to sit down and come in there.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Denons, also known as...
Kayleen says threatened by both sides, paid by Melly, forced by prosecutor to appear. The Melly thing, allegedly. Damn, it's the state. She says it later. They also threatened her daughter with jail time. All right, gangster.
YNW Melly. Romantic relationship.
22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Denons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I'm thinking maybe 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
Ooh.
And what's he wearing?
Wow. Yeah, you're right. Look how she's smiling.
See him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Yeah, the record reflected in court identification of the defendant.
Yes, the record will reflect the in-court identification.
To me, like googly-eyed and stuff too.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't, no.
Okay. Did you know if he had social media at that time?
I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry?
What was your social media name?
My name? For which one?
For Instagram.
Instagram, it's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th, 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly.Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
No. Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Stack and Julie.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th to 1749 UTC. Start with this one. I'm going to.
All that extra shit, and like, they leave the most important shit here for the baby.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one here.
Oh shit, like, get right there, like, you know you come back.
Oh shit.
Whose
Sorry.
driver's license is that?
That's my daughter.
The conversations and things. The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
All that extra shit, and like, they leave the most important shit here for the baby.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Janelle.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was what was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot in that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
Oh shit.
I would hope not. I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so
Of course.
I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened,
Yeah.
you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't remember.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie to stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything, I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So,
Okay, I'm looking at the PDF because I can see some of the conversations that she had said in the deposition. Okay, we'll just keep watching this.
Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered. Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be
Okay.
clear. All right? You asked your question again.
Okay, so Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Oh.
I don't
Not that I
remember.
recall.
Okay, going forward to the events of that day,
Yes.
when you heard that phone call, where were you?
I'm home.
Okay, where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of with looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think
Oh, shit.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Yeah, she said no. Oh, fuck.
Good one.
Okay. Would you like statement help refresh your memory as to what?
No.
Anytime I've watched this trial stuff, and I've only watched a few, right? The ones that I've watched have been here with you guys, so it's only been a couple. But I've never heard them saying the ones that I watched that they're like, would it help you refresh if you looked at it? They always say like yes or whatever. This woman, from what I've seen, this woman's like straight out, nah, it's not gonna help.
I don't think it. Good one.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing her page 3.
Yeah, show it to her anyway.
And so I'm going to ask you, Ms. Holmes, to just read this part silently to yourself.
Okay.
And I'm going to read from, we're going to start here, this, and through here, okay? Silently to yourself.
I don't know if they can still put it on you though, even if you say no. Oh well, we're gonna show you anyway. I thought like, okay, that's the first time I've ever seen them be like, nah, it's not gonna help.
When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection.
Can I see, please?
Yes, Your Honor.
Ladies and gentlemen, it's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case. There's certainly no research, all right? Leave no head on your chair. Sorry for the delay. What time is it? Let's say 1:30. Thank you.
his phone? Stand.
Oh, sorry.
Right there, thank you.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, assistant state attorneys, and our witness. Madam, you want to step outside for a minute? Thank you. Just wait outside. Thank you. So what are you anticipating this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know, he never called it. There was never answer. You have the 772-713-9807? Question, 9807. Answer, I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme? That what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, he's like, yeah, there's some. I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juvie? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Bivens is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes.
Tara, thank you so much for the super chat. Appreciate that. And thank you on Facebook for sharing, Tasha. And Ebby, 18-month member, says, sup, brother. Thank you so much. Appreciate that, man. Thank you for the love. Thank you for resubscribing all that time. I'm looking at the PDF, but there's a lot of information on the PDF. I was just trying to kind of get to the point. But maybe I should just focus on what happens here, and we can look at the PDF later, maybe.
There's another part later on where she then describes the conversation again that he said. He just basically said that his friend just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer, it's like I don't know. And I said, we're on our way, just, you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned she may or may not remember.
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically, the portions that you just elicited.
Yes,
Correct.
and I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from now? What are you reading from now?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December.
So interesting thing, because you want to be aggressive, but you can't come for the judge, upset the judge, I guess.
14th, 2022. Will clarify the issue.
What's wrong with laughing, though, if you thought something was kind of ridiculous? I guess you can't do that.
Of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock in the morning. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and the first thing she said there, she's not talking about Jamel, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and are I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not permitted to make.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And that
Honor.
was taken under oath?
It was, yes, it's a sworn statement from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that, those were actually clarified because defense provided the state with reciprocal discovery of Ms. Jamie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Jamie King that is shown in Miss King's phone records.
Who's Jane?
Mohawk Mom says she's recanting for the money, allegedly. Shelly, thank you for the 4-month membership. Says was literally homesick for y'all. Grateful for you, Mel. Yeah. I'm a little. Oh, you mean us? I thought you maybe like literally homesick, but like homesick for us. Like, yeah, I get it. A little slow. All y'all questions going to be answered. All right, let's keep watching then. Shelly, thank you for gifting the membership, as well as Amy. I forgot to mention this earlier. Amy gifted 5 memberships earlier. Thank you so much. And I need to check in with you too. I know we texted, but I need to call. All right, let's keep going.
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take a statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Mo says, but the money in question is $5,000 versus her previous $9,000 a week. According to her, is it? Do I rewatch my lives? No, not really. I mean, maybe sometimes if there's like an audio issue, there's sometimes things that I realize I should do differently to try to improve the rewatch quality. But no, for the most part, I really don't. Sometimes I might skim it, but that's about it. Like when sometimes with the chases, sometimes people complain about like certain audio or like the screaming or whatever. So like I go back sometimes to listen to see how it would sound.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice, we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact when there was no evidence to suggest that. And she said she was acting then under threat and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you.
So, counsel, I've looked at a couple of cases that came across. First is 880 Southern Second 561 Pierce v. State, Supreme Court of Florida, and the second 993 Southern Second 1108 4th DCA case SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence. And the state, his response was he didn't recall, don't remember, anything along those lines. And the end result was that the Supreme Court said in order to resolve this claim, I'm reading from the 8th page of the opinion, it said in order to resolve this claim, we must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. The second case I have is SL v. State, as I said, 993 Southern Second 1108, and that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. It goes on and says, interpreting this.
Should we skip this back and forth arguing stuff to when she comes back on the stand?
The Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. It doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness denies remembering the statement and you want to read it to him, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my thought would be just to keep it out. So I sustain the objection.
So Your Honor, just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection recorded, which is a very specific subset. So I refer to Earhart on that specific issue, 9803 sub 5.
Excuse me one second. Could you get right here? I left it on my desk.
The judge ruling is important. The prosecutor ignores the ruling. Okay, so let's see. Because he ends up making an order not to do not talk to her about her statement. She doesn't remember. And if you refresh and she still says she doesn't remember, you need to drop. All right, so let's check it out. I ordered some food. We're just chilling, man. We're chilling, riding it out. Tomorrow we'll be caught up. Tomorrow should be interesting. Hopefully it's man, I could skip this, right? I don't know why I'm sitting here. It's this part.
Go
back.
I'm sorry, Counsel, what section are you talking about?
9803.
In airport.
Yes, subsection 98035, which in the 2022 edition starts on page 1104.
Ride it out. Yeah, Melissa, I missed that trial. I was gonna do a redo of that trial, but thank you.
For your honor,
Please reading, going over
it
it.
is the Florida Supreme Court 2013.
And there's some reading, right?
Counsel, my thought is called the hearsay.
That's right. Okay, here we go.
All right, I've read the case. Anything else you wish to share with me, Counsel? How about from the defense? Anything else?
A commentary on the case that was just provided.
Yep.
I think the polite case, the very first headnote, says that the admission of past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum or record. The opposite of that.
Excuse me, and that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion, In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
Absolutely correct.
Counsel, my thought is this. If what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right? So, are you ready to proceed?
Yes.
All right, let's bring the jury. Are you ready as well?
Oh, did we miss the order or was that the order?
Defense, you ready as well? Yes. All right, bring the jury in. Yep. Bring the witness in, bring the jury in.
Grab the witness.
Thank you, State Attorney. Ladies and gentlemen, jury, our witness, Bishop Holmes, remains on the stand. Ladies and gentlemen, I apologize for the delay. It's my fault. In any event, I think we're ready to proceed now. Ms. Holmes, I just remind you, you're under oath. All right. Thank you. Proceed, counsel.
Okay, so I'm going to talk a little bit about your deposition.
Yes.
Do you recall, and you've been provided a copy of that deposition?
Yes, I did. My lawyer got provided a copy.
When you, in that deposition, were you asked if your prior statement...
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were you?
I understand. The deposition that I did on December 22nd? Yes, it was given to my lawyer yesterday, right before, briefly to look at, yes.
Okay. So the deposition you have, that was
It was
provided
given to my lawyer
review?
yesterday, yes it was.
Okay. So, do you remember coming into that deposition?
Yes, I do. I was in jail, put me in jail.
Correct.
Oh,
And so,
oh, shit. Because they locked us up. So, yeah, I remember. Put my ass in jail. I remember that deposition.
Yes, I do. I was in jail, put me in jail.
correct.
You put me in jail. Oh.
In the position.
Yes, I do. I was in jail, put me in jail.
Correct. And so it's clear in terms of you don't want to be here.
You're making me be here. Yes, I have
Yes.
a house, a band on my leg. I'm a nurse. I can't even work properly. Yes.
You were under house arrest because you failed to comply with the subpoena.
Let's go!
I can't even work properly. Yes.
You were under house arrest because you failed to comply with the subpoena.
No, you did not serve the subpoena.
Sustain. Listen. How we're going to do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I am.
All right?
Yes, sir.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yes.
Do you remember coming to my office?
Yes, I do.
Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember anything, but I'm pretty sure I do.
Okay, so what I'm going to do is permission to approach her
With what, Counsel?
for deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw my
Excuse me. There's no question pending if you. All right, you can proceed, Counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th of 2022, where you asked if you need to make any corrections or deletions to the statement of December of 2018.
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in the statements?
I don't remember, but that's what's on the deposition.
Okay. So December of 2022, you said that this is a correct statement.
Objection. Sustained.
So Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Ask and answer.
Excuse me. You have to I understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, let me answer the objection first.
Yes,
all right? The objection notice overruled. Question is the statement, repeat your question.
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that would
Excuse me,
help.
one at a time. All right? Just one at a, let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me. Thank you. Not as to this. Go ahead. Overruled.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Broward County?
Yes, I did.
Who did you come with?
My daughter Mariah.
Okay, where did you go?
We went to one of Janelle's friend's house.
And whose house was that?
Frida.
Okay. And now approaching what's been previously shown to defense counsel and marked as states triple N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's boyfriend.
Okay.
I'm sorry. I apologize. I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Janelle from dating my daughter.
Your Honor, at this time, state we request to move states triple N in as the next numbered exhibit.
Any objection?
Relevance.
Overruled. It'll be admitted.
States triple N, be marked states 62.
What they gonna do?
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Why don't you come sidewalk?
I think it's relevant. What are you doing here? Murder on my mind. All the time. All the time. All the time. It's on my mind. Think about murdering you all the time. What are you doing? Maybe he's rapping to himself.
Development's manager. Gotten again.
Yes, ma'am.
Okay, so I'll ask again.
Yes, ma'am.
How much money have you gotten from the defendant development's manager? And with regard to that specific statement. Ms. Holmes, you have formerly had a credit union account?
Yes, I do launch credit union.
Okay. And at Launch Credit Union, you banked there for a number of years?
Many years.
The credit union that you've been at, it's been your account, and I won't put your account number on the record for that reason.
Can I object to this line of questioning based on the court's ruling?
Objection, that's over, proceed.
So your testimony is that you have never been given money whatsoever.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For a vacation for all of us, for him, his wife, and me, to pay for it, as far as, he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that.
So he did give you money.
Can I hear this shit again? I want to hear it because I had to. It's low. Let me turn it up. That part is really low.
Objection, that's over, proceed.
So your testimony is that you have never been given money whatsoever.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For a vacation for all of us, for him, his wife, and me, to pay for it, as far as, he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that.
So he did give you money.
Not for personal use.
Oh, please.
Excuse me, can we clarify who he is, Jameson Francois?
Objection, no, just clarify, counsel.
So it's clear, who is Jameson Francois?
He's Nelly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We're all good friends.
So I'm going to go now. It's previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay. And
Right.
in terms of
Vacations not personal use.
individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward to the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a sleep. I don't recognize this conversation.
Okay. With regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a sleep.
What happened to it?
Objection, relevance is sustained.
Aaron, may we approach that?
Sure.
Just about snake. Damn. So he was paying her $4,000 a week for a vacation and shit. Damn. Who are you talking to? His mama?
So, Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea. I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't.
In terms of, did you review your statement of December 18th of December 14th of, December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
Overruled.
I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would know, but you can show it.
You have permission to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to yourself.
It's interesting. Most keep in mind she is considered a hostile witness. Hostile. I love that. I want more hostile witnesses, forced witnesses. That's awesome. So she can ask leading questions at times. We should Google some hostile witnesses.
Okay. Looking at that, does that refresh your recollection as to what your daughter's phone number was?
I still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the number.
I got 3 daughters, so I don't know.
Understood on that one. So, do I have permission to treat the witness as hostile? So, do I have permission to treat the witness as hostile?
Objection. Want you to sidebar, please?
She said, can I treat the witness as hostile? I love it! I want to see more hostile witnesses, man. I want to see this shit. I want to see a compilation of hostile witnesses. Clearly, she's bullshitting. She's a bullshitter. Clearly. But, I don't know. Lock you up, force you to come make the depot. Now you gotta be a witness. Hostile witness. This is really problematic, though. I don't know how this helps.
As you go to jury, do not discuss.
Oh, they're gonna send the jury back.
Case, don't form any opinion about the case going on. I want you to
Yes, whispering in his ear. I got you, boo. Hurry.
remain along with the defendant. Witnesses on stand. Ms. Holmes, my understanding from counsel's side was that you have an attorney here with you, is that right?
No, I was told to bring him in here.
Might be a good time for you to talk to him. So, you want to speak to your attorney? Any objection to that? by the way?
Yes,
What's
yes,
the
Your Honor.
objection?
The witness is on the stand, and for the state to suggest to a witness who has already been sworn and is in the middle of testimony that she goes and talks to her lawyer, it's kind of intimidation, coercion. I think the rules have been, so we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys. This is the concern I have. You're asking me to declare her a hostile witness. So here's the issue is, I don't know what's your position on it. She's at, that would allow her to ask these legal questions as she suggested at sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, you know, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she's basically saying, you know, she doesn't know, or that's the end of it. I mean, you can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z? The police officer, she's not acknowledging she said it. I can't see, you know, how you do that. You can't.
So Your Honor, I think I can ask the questions because
What question?
In terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information?
What information?
Whatever the particular statement may be that we're at that point in the questioning. For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number. So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made in some other proceeding at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
Mr.
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to, because we knew that this debacle was going to take place, I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse, a 90.803 section 5 ruse, is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it. But then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 8035 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm going to read it out of this report and say, didn't you say that? So what happens is we're going to now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she has previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitchback.
Oh no. Hell nah. The promises that were made to us by WNY for me to quit my job so they would take care of us were all lies. Maybe they held up on their promises now. Maybe they came through. They didn't want us talking with prosecutors, but now they have disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go back. We can't go home. We're spending all my money I worked for and they taking trips and enjoying life, living that good life. If you think I was a beast before, wait until this trial. I'm not holding back anything. I'm doing what I should have done in the beginning. They can call me Miss Snitch. Ooh. Fuego. Fuego. Oh my God. Now I know the jury didn't see this and this is inadmissible and blah, blah, blah. But for me, oof. I mean, clearly this lady, she's lying. I know I can hear Mo's, but she has that right though. She does have that right to be like, I don't recall. But I can hear Mo's in the back of my head. And I could be like, well, she's lying in the court under oath. But she does have the right, I guess, right, to plead the fifth. Can you lie? But that's still a lie, though. If you're saying you don't recall and you're lying about not recalling, that's a lie, right? Isn't that still against the court and shit, the rules and stuff? Oh, thanks, Mo. Appreciate the super chat. It's car fix fun. Keep Maddie safe and yeah, I might get a new one. I'm not sure. I mean, right now I'm chilling. I got it fixed, but I'm not really sure because I'm almost gonna get to the point where I'm gonna put more in the car than I actually bought it for, you know. But I'm just chilling now. We'll see what happens. So that she lied. How's the defendant's girlfriend's mom not considered inherently biased based on her position in relation to the defendant?
So, Judge, it's very clear from this record that my intention and what
Say
the
mistrial?
witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same
I guess that's true.
Instagram-
So you guys are saying, but how do you know? Okay, but just Ryan, how can you prove that they recall though? That's true. And somebody else said, Hannah says if they could prove that she does recall, they cannot. Okay. All right.
production, and this is in June of 2022, Felicia Holmes is saying, they made me quit. Told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making
But how can you forget this? You really forgot all this? Come on, bro. And if you're showing the deposition, doesn't that help you recall? You know she lying.
1,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor.
Memory is fluid.
So, Judge, in terms of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear
That's
that
true too. Sandwich says because you swear that your statements at the time are truthful. I mean, they can use this against you in court.
this witness has received multiple benefits from the defendant based on her own.
Yeah, but if you have sworn testimony, if I said some shit, especially like my exes and shit, they're like, oh, you don't remember? I don't remember. But if they had recorded me, which I don't want to encourage them to, and it had some timestamps and shit, and I see that it's actually from me, then I'm gonna be like, yeah, I don't remember, but that's true. I guess that's what this lady's doing.
Statements there that she has endorsed that was.
I remember,
her
Mel,
Instagram.
5 years ago.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence, I forget the statute number.
9803 sub 5, it's a past recollection recorded.
Past recollection recorded, and you
Correct.
gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria on the other issue about.
Mohawk says, sorry for the interruptions. Mohawk Mom says her saying I do not recall is lower than saying I plead the fifth. Okay. Oh, Amy, thank you so much. You're so nice. You're too nice. You're so gracious. Send me 100 for Car Fix Fun. Thank you. Love you. Love you. Don't worry. We'll get into a trial soon enough. We'll be doing daily. I mean, we might do this. We might not. I think we probably will. Who knows what's going to happen tomorrow? Because this shit could end tomorrow. I don't know. What are all the legal YouTubers saying? Attorneys saying? What do they think? Can we mistrial or not? Amy, thank you so much, man. You're so kind. And she's been super supportive too in the last trial. You do all the maintenance it's up for. Yeah, I was gonna take it to the. I thought about that, taking it to the dealership, because there is a few recalls. I think they do the recalls for free, and then you can catch it up. Whatever. Find a shop you can trust. I don't know when I can trust. My friend, the one that I used to go all these months that I was going to, a friend of mine that's really good with cars, he was like, you can trust him. Now, a couple of days ago when I called him, he's like, don't trust that guy. He's a scumbag. I'm like, okay, all right. So I called a different friend and she recommended me a different place. All right, let's keep going. Let's keep going. Nancy Jennings, thank you so much for the super chat. Is the ex-girlfriend going to testify? That is a great question. I would think so. I would love to see that. And is she going to be a hostile, quote unquote, witness too? But who is she testifying for? Is on behalf of the prosecution or the defense? Maybe the defense. I don't know. Thank you, Jennings. Nancy. That's it.
Impeachment. You know, this is not what she said. She's, you know, she said gave me a different answer. What I tried to read before was something from a couple of cases, and again, the synopsis of at the end of it. This is I'm just reading again from the SL, a child case, the state 993 Southern Second 1108.
They can't find the X? No. She's MIA? Cali Connect. Oh, hell no.
It just says the Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at an other proceeding. So, then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now,
So is it two different things? The statement and the deposition? Are there those are two different things.
I do have a message from Mr. Bears, B-E-R-E-S. He says he is Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. To be candidly, I'm assuming it's his testimony. But anything he could say right here in open court. I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take that as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, you know, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
For what?
Thank you. All right, let's...
I'm surprised Joe's in the snap. So this lawyer a little sassy too.
Anybody need a restroom break or anything? You ready to go?
Yes, sir.
Pardon me?
Judge, I think someone on the defense.
I need to go to...
Sure. We'll take a short recess.
Just for the prosecution, don't they have two attorneys? Who's that? Got the whole courtroom paid off and shit. Damn. We got money. I'm just kidding.
The past
What the hell was that? Loud bang.
And I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think if the state has something that's admissible that they can prop to this court, that witness needs testimony needs to be concluded.
Thank you. Stay with you.
Judge, the state's not. There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. this pursuant to this hearing where she was, I think you said she was in my house?
Yes, sir.
Regardless, so I will allow that. The problem I don't want to have happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that that statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not. It's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So is your
So I don't want you to get in the back door, but you can't get in the front door.
No, just so I can make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or-
I didn't
okay.
say that. What I said was the statements in the police report, right? You can't just read that back to her. Didn't you say this to the police officer? I don't want that.
Isn't that the whole thing of leading? He's saying she can lead, but she can't lead. Or I guess she can't lead with anything that's in the statement, I guess.
Being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
she'll ask whatever question she thinks is appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what she, that statement is truthful, so I don't want you to just be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, we'll see where it goes.
Yeah, just one thing, Your Honor. I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's going to get a no, and she's just putting it into the record. It's improper. And I've
Hopefully I
asked,
made myself clear, but that's why she's going to be able to, counsel's going to be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule. We're going to go forward like that. I don't know what you intend to ask, counsel. I just don't want the contents of that statement, regurgitation of that in some form leading questions, all right? All right, bring the jury in. Let's get the witness back in.
And I remember with the Murdoch trial, like I feel like there were a couple times where they did mock, I don't know what to call it, mock questioning or whatever of the witness without the jury there. The judge can decide if he's going to let it in or not, rather than just shooting it live from the hip and kind of seeing where it goes. So, but It takes a lot more time to do that, though. But Mo, tainted watcher. You watched it all, Mo. Fast forward a little. Almost done for today. We didn't do too bad, actually, for today.
Thank you.
I'm sorry.
Hostile witness. Hostile. Like, every state is different. That's true. They may allow that until like Carolina. Yeah, I don't know. I just thought it was interesting to kind of preserve the trial. You know?
Jury entering?
Does the jury knock, or is it the security guard knock? I know, right, B? She quit her job for a reason. Her whole life changed. How do you forget why?
Yes, sir.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure, it's not here, I'm pretty sure.
Okay. Do you remember the name of that pet snake?
No, I don't.
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I know who the owner was, it was in the house with Mariah lived.
Okay. Where did Mariah live at that time?
She lived in BMR.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Okay.
They're talking about this pet that passed away, which I'm assuming is that snake. They were trying to get in earlier that they were talking about the snake. And I guess she lived with Jamil. I think that's what she said.
And do you know the address?
The daughter.
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Okay. Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection,
That's
ask
4 years
and
ago.
answer. Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So,
Oh, you said, of course. Oh, that's convenient. Your trauma. Of course. Oh, shit. To be fair, though, I saw some other people saying this in the chat. I don't remember my phone number from years ago. I don't remember the most two recent numbers that I have now. But if I did see it, though, I would recognize it. If I have some old numbers that I can't remember off the top of my head. What's going on out there? But I would recognize if it was on like paper or whatever.
is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drive-by.
No, because they said his friends had been in a drive-by.
Okay.
That's what?
And involved in a drive-by.
Oh, drive-by.
No, because they said his friends had been in a drive-by.
Okay. And you were worried about him because he was hiding in some bushes.
Objection.
I don't remember his bushes.
Okay. What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any blood.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay. Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall an Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Is that Mark Council?
Not yet, Your Honor.
Ex's mom, yeah.
I don't remember it. I don't remember.
You don't have any recollection of that?
I don't remember.
Is that your Instagram, BlingQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it all.
Okay. Is your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
I don't remember making those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Boardman.
No.
That's I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me and asked me that I threatened to kill Boardman. And I said, no, I did not threaten Boardman.
Okay.
I remember that.
Was there any threats made to you by the defendant?
No, not at all.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And it's your testimony to the ladies and gentlemen of the jury here today that you saw Jamel Demons on October 26th of 2018.
Yeah, I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him, yes.
Okay. And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yes.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jane King?
Yes, I did call Jane.
And in terms of the conversation with Jane King, that occurred immediately after the FaceTime?
Not probably immediately, but sometime after. I'm not quite sure the time. I don't remember what time it was.
Okay. And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would lie?
I don't remember my first statement. I have no reason to lie to you.
Yes or no? Did you lie to police?
I did not lie to you, no.
Yes or no, did you lie to police?
No. I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I didn't. For me to say no, I didn't lie would mean I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of it here.
I looked it over and I still don't remember it.
Okay. Well,
I did it over 100 times. I don't remember.
Well, if you'd be so kind as to do it one more time.
Yeah, sure.
You can say that to this jury that
I don't
this
remember
is
that.
not truthful.
Yes.
Please.
Objection asked and answered
shit.
5 times.
Oh, shit.
Objection noted.
Uh-oh. Brittany, thank you for the 7-month membership. So good. Amazing. Brittany C.
I honestly God do not remember any of this on here. Like, I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to lay law enforcement?
Objection.
Excuse me, can I
I'm
see
just
side
Whoa, hold on. What? Slow down a little bit. Slow down.
I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to lay law enforcement?
Objection.
Excuse me, can I
I'm
see
just
side Quiet, please.
Man.
I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to lay law enforcement?
Objection.
That year, so it's a lot that I don't remember about that year.
Is it your practice to lay law enforcement?
I'm
Objection.
gonna lie to law enforcement.
Excuse me, can I
I'm
see
just
side
enforcement.
Quiet, please.
So, Ms. Thompson, is it the transcript that you're saying is on that academic version?
Sustained.
I don't know.
Excuse me, sustained objection.
Okay, so going back to the relationship with your daughter and defendant.
Yes.
How long did that last?
3 years. I'm not quite sure how.
Okay. During the course of that relationship.
Oh, is it your practice to lie to LE? Okay, thank you, Rose. Amazing. I don't know how you guys can hear it. I can't hear this shit.
Did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frido's house, is it your testimony that your daughter went upstairs with Mr. Dennis?
She did. They did go upstairs.
They went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward, maybe, I can't really remember the time, maybe, I don't know, but 1 o'clock, it was after lunch, because we went to right after. So it was lunchtime, it was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went with?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony is very that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember exactly what he had on, but I just remember that there was no blood because that would have freaked me out. So I know he didn't have any blood on him.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
No. Is it your testimony to the jury that there were other individuals present at that house?
Yes.
Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, she was.
And in terms of your appearance here today,
yes.
You don't want to be here.
Yeah, you might not be here. You made it on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena
Never served me.
and so you were ordered by the court to show up.
You never served me originally. That was a lie.
Oh, she's trying to say that, I guess the first time maybe she's talking about, or whenever, when she got arrested. And she said, you never served me.
You never served me.
And so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to,
Got fired because what?
did you quit your job?
I got fired because you put me in jail.
Oh, because you put me in jail. I don't know why it's, I mean, I have the sound booster for you guys. I have mine maxed out on my end, but I don't hear the extra audio you guys are getting.
And prior to that,
Yes.
before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job?
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay, so you left your job?
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I make my own money.
Have you ever made statements contrary to that?
I don't remember.
If I may approach her?
Your Honor, objection.
Just show counsel.
That's it. You don't remember getting paid?
Can we approach?
Sure.
Robert.
Ms. Holmes. Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
I don't never say anything like that.
If I may approach her?
Sure.
If you would
Just read this. I don't remember that.
Okay,
Yes, gave me money to pay my bills.
so Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move mistrial.
Thank you. Why don't you go sidewalk?
There we go.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never say anything like that. I know what's ever made me quit my job.
Objection.
If I may approach her?
Oh, Lord. Oh, approach her.
I'm going to show you this next few minutes. Okay. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I
Objection.
never say anything like that.
Okay. So you're denying making that statement?
I never say anything like that.
Oh.
Objection.
Your Honor, can I just have a standing
Yes.
objection so we don't keep interrupting?
Thank you. Any statements you heard on the standing objection?
Whatever defense is chooses to
Go
proceed.
ahead.
Okay. So, Ms. Holmes, in terms of
What just happened?
you made a statement to the effect of you were told to quit your job and the defense would take care of us.
Objection.
No.
Excuse me.
The defense? No.
Why don't you come sidewalk?
And we have another motion.
Lord. Saw her face? Lord help me. All right, let's see.
Ladies and gentlemen, there was an objection made to the last question. I made a determination that was an inappropriate, improper question, and the way it was phrased was totally improper, and therefore I sustain the objection. I am instructing you that you are to disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So your testimony is that you've never said that.
I just I don't remember.
Excuse me, counsel. She answered the question. All right? Let's move on.
So
Shit.
Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So your testimony is that you've never said that.
I don't remember.
Excuse me, counsel, she answered the question, all right? Let's move on.
Oh, so he's getting on the counselor because she did answer. Oh.
Your statements with Portland Henry. Do you remember speaking and talking about your daughter with Portland Henry?
No, I don't. When was that? I don't remember.
Sure. When was that? Here, I'll give it to you again. This was February 5th of 2021. You still have it?
Oh, no, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
No, not that I can recall.
Ms. Holmes?
Christina said, she said, did the defense promise to pay you, implying the defense team?
Did your daughter tell you what happened in this case?
Objection.
No.
What's the objection?
Comes for hearsay. It's immaterial.
Not what the statement said, but did you say something about the case? It's overruled. Not
she
what
never
was
told me
said.
about-
Just
she
did
never
you have
told
a
me
conversation? Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter
Never, she never
ever
told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Oh, the judge looked frustrated too.
Can we approach?
Yes.
Shit, what a shenanigans! What a mess! Mess. The prosecution needs more people, man, on the team over there. They kind of looking weak. I don't know who the other lady is, but she don't really know shit. Maybe later on she comes into play, but this chick needs some help. Ayúdale.
No research. Just leave your notepads on your chair.
Are they taking a break? That shit go backwards for a second? Did the video just... Oh. She just stepped backwards. That shit looked like it rewinded or something for a second. That was some Black Mirror shit. Hey, what was that? I want to see that again. Yeah, what the hell was that? Oh, she just stepping backwards. That's what happens when you watch one episode of Black Mirror. Everything starts fucking like tripping you out. All right. Even the sound sounded like it rewinded. I don't know. All right. Glitch in the Matrix. None of this is real. Melly. Ooh, they giggling and laughing. Oh. Oh. She probably feels on top of the world right now. Ooh.
The attorneys, the jury's not here. They're adjourned. We all ready to proceed?
Yes.
All right. See if they're here, please. See if they're ready.
Here we go.
Tell me about this one. I asked you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
Did she tell you what happened without? No, she did
Just
not.
so she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to the lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidewalk. Proceed to your approach.
Showing me your messages from Instagram from February 5th of 2021.
Who was that Instagram? Is that the one? The Instagram stands with Portland?
Ma'am,
I don't
sorry.
remember. I don't remember that Instagram.
Look at it.
I already looked at it. You want to show it to me?
Get a good look at it.
So is the
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't
a
recall
statement
making that
from
statement. No.
Excuse me, one at a time.
Ooh. Ooh.
3 times already.
So you don't recall making
I don't
a
recall
statement
making that
from
statement. No.
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying?
Objection.
Sustained.
So, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection. Asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection.
She
Asked
did.
and
She really
answered.
did ask this shit.
Into the statements that, with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle the
Yes,
witness.
sir.
All right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Ms.
Jesus.
Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidewalk? I want to see the question, please.
Oh. Defense on it too. They let nothing slide. Acting answered.
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase your question to specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
I don't even think the judge knows himself. Don't know what to do either.
Were you present when your daughter spoke with law enforcement?
She was 17, I had to be present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No, I don't.
And you got a weird cough.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for a conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
Yeah, he's just standing. He's like, you know what? I'm not even going to sit down anymore. I'm just going to stay standing up. Just call the objections.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
One.
Yes, sir.
You came here and one of your first. Let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the
Let's
prosecutor.
go!
This prosecutor.
Order
Yes,
up!
I did.
Thank you.
Ooh, yo, I didn't realize that. I like the heels. I just noticed that she got like some fiery red heels. Oh, shit.
This prosecutor.
Okay, I'm feeling that. Matches to the personality. Okay.
Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This
Look at that
prosecutor.
shit.
Yes, I
Oh!
Thank you.
Anything else to this witness?
Yes, Your Honor. Ms.
Oh,
Holmes,
yeah, I didn't notice until
you said
now.
you feel threatened by
Of
me.
course.
Okay.
Hey, what you say? I was distracted.
Ms. Holmes,
Yes.
you said you feel threatened by
Of
me.
course.
Okay. Did you fail to appear for
Oh, hold on,
numerous...
you know, I realized it's a little bit cropped. I need to fix the crop for the heels. Let's see that. There we go. Let's fix this shit up right now. Gotta make adjustments for the stream. Okay. I didn't know. Maybe that's why I didn't notice all the time. Okay.
court appearances?
No, you never served me. Lied.
Okay.
You lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay. Material.
Overruled.
And so that was a location you were at?
That's where I was a shop owner's side. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. You served it to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse tonight?
Excuse me. Come sidebar, please.
Okay.
So, Ms. Holmes, you even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. If I could go to my job with this, it's embarrassing. People think I'm a criminal. The state has run my life.
Wow.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling
Have you-
you.
that's not-
Oh, this is interesting. Oh, it just
Run my life. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has to run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you,
Have you- that's not-
I don't
there
understand.
cannot be-
Excuse me, hold on. Only
One
one
time,
you
yeah.
can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So that my question was non-responsive on that one.
Ask your question.
Oh, yeah, she need to get aggressive with the non-responsive shit.
Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because you tried to get him this far.
And no, that's a false statement.
Objection.
Yo, this guy jumped up. I'm trying to understand. I don't know why the audio doesn't sound so clear to me. They're talking about the attorney hiring her private attorney.
Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because you tried to get him this far.
And
She says she had an attorney.
to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because you tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me, counsel, you're not testifying.
I
all right?
agree on
You
that.
excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid?
You never served me the subpoena that was never, you never served me.
Oh, this is so nasty. Oh.
Subpoena that you never served.
And that was found to be valid?
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you using those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court?
Objection.
I've
That's
served,
an
I've never
answer.
been
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on that, have I ever any sort of physical violence against you? Okay. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As
And
of now.
And in
Ah.
terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me. You
And
served
you,
a subpoena at the jail when I was in Brown County.
and you understand you were here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compel the attendance of witnesses.
I've been complying.
And nothing further. Your Honor.
Anything further?
No, sir.
Thank you. This witness excused?
Yes, Your Honor.
Thank you, ma'am, you may step down, you're excused.
I was kind of looking forward to the cross. I thought he was going to ask more, but I guess that was it. The defense. I thought they would have tried to turn on her to throw her under the bus too, but I guess not. I mean, it kind of. Ooh.
Please sign letter, please.
I know you're going to smile. Where's it at? I know you got to smile. No smile? Oh. Monday's a holiday. So Tuesday, tomorrow, we'll be back. Vamos a estar para atrás en la mañana para ver lo que pasa.
All right, same admonition I give you every time we break. We're counting on you to follow it. All right, just leave your notepads on your chair.
It's like, yes, we did it. Mistrial. We got this in the bag.
We'll see you back on Tuesday, 9 a.m. Thank you.
We did it. Yes.
What did that? the record reflect the jury stepped down. Counsel remained along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if it was, I don't think there was any evidence that she had something that might have been marked as an exhibit.
It was not marked, Your Honor. It was just a copy of the
So
transcript.
you're okay with it?
Yes, Your Honor. I have plenty of copies.
In any event, so jury's been excused, counsel remain along with the defense, so you have a couple motions from this trial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, it advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted, and we move for a mistrial.
Tainted juror.
Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that might be.
This is your motion for Mr. Armstrong?
Yes, it's our motion for mistrial.
There's a second one. All right, go ahead.
Well, it's the second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. No. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper. And the court...
What's the judge looking at? Like he has his head down and shit, like about to sleep or something.
Told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today.
Oh.
Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation made by...
What about the other one? Any of them ever spoke to that lady or what?
State that's the defense.
I know you say you did it, but did the henchman do it?
I met her at the depot and saw her today.
For the record, it was my first time ever seeing her.
Oh, okay, all right. Ow!
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context. That
he's pissed. You say, he's pissed. Like, the old man, he got a little spice in him too. A little angry shit. He was about to launch up into the air. Watch this shit. Watch it. Right here.
So defense implied or read into that in some additional context that was not.
Sit down, calm down. What's wrong with you, Bob? Back, relax.
So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account.
They've been zooming in on him or Melly
on that, and it's very, in terms of the forming the question.
Look at his face.
It was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
Take it easy. Oh shit.
The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial.
Of course he's going to go for it too.
Appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk with your client about it. We'll see everybody back on Tuesday. All right.
Yes, sir. Have a good weekend, sir. Judge, since we're breaking early today, can we have a few minutes with our client?
Sure, I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off while we talk about it?
I can't hear you.
The camera's off.
Oh, you want privacy? That's fine. Cameras can be excused. They can go out of the courtroom.
Thank you.
Guys, everybody can go out of court. All right?
Thank you so much.
Thank you.
Adjourn. This is like a private conference area.
Thank you.
Caliente, caliente. Oh, caliente, caliente. I like the little corrupt, tainted attorney. I like her. Caliente, caliente. Allegedly, I'm just kidding when I say that. I like it. Oh shit. Oh, that's not happening. Melly. Corrupt. Tainted. I'm just kidding about corrupt. But I don't know, man. I don't know what's going to happen. So it's going to be interesting. So the judge didn't decide, I guess. And so tomorrow maybe we'll hear. Oh, man. Mistrial. On Thursday, John Murphy oversaw the defense termed a fiasco in Broward County, a lengthy and often dramatic series of improper questions directed towards a state witness, as well as testifying directly. Care of lead prosecutor. The witness, Felicia Holmes, the mother of the defendant's ex-girlfriend, Mariah Hamilton. The judge said he has not made up his mind and deferred to a discussion and ruling on the matter until the court is back in session next Tuesday. Tomorrow it's going to be interesting. But comments he made only to the defense suggest the court was somewhat sympathetic towards the defense's claims of a tainted jury. I suggest that you talk to your client. The Judge Howard and fellow defense attorney Stuart Alliston, before referring to Melly by his given name Jamel Demons, discuss with Mr. Demons whether or not his feelings about a mistrial. But why would he be against it? Damn. Man, what do you guys think, man? What do you think will happen tomorrow? Tell me what you think. Sandwich says, I think they're all in on it. It's all set up. They're all paid. Want to do a poll? Okay, we'll do another poll. Will there be a mistrial? Oh, real quick, too. Let me show this thing right here. I'll tell you, man, men, you gotta be careful these days. Sylvia sent me this story the other day. I think we talked about it briefly. I gotta head out of here soon, too, because I gotta take the baby to my mother's for a little bit.
Well, in other news, please.
Her hair and stuff. We're gonna chill over there.
So looking for this woman, her, who they say stole
$600,000
worth of jewelry from the victim's home after meeting him at a club. NBC6's Jamie Garola has more details on what cops call an...
She walked out with the cups after leaving the apartment. I was talking to Sylvia about that. Maybe she didn't want the DNA on there or something, so she'd take the cups. Oh, hell no.
$100,000 worth of jewelry from the victim's home after meeting him at a club. NBC6's Jamie Garola has more details on what cops call an expensive date.
Miami police say that woman may have walked away with hundreds of thousands of dollars worth of valuables, but she also left with some key evidence. Take a good look at this woman. She's tall, could be considered good looking, and
could be considered good looking. She's tall.
Take a good look at this woman. She's tall, could be considered good looking, and according to detectives, slick. Police say she met a man at a club last Monday and drugged him. While the victim was knocked out, she allegedly cleaned out his safe, taking $600,000 worth of valuables. Women overdosing their victims to steal from them is a scheme that's all too frequent in South Florida, according to the former director of the Miami-Dade Police Department, Juan Perez.
It's the same warning that we have for women taking drinks at bars from strangers.
Yeah, you guys got to watch out too.
Watching the bartender pouring in the drink. It's the same rule that applies for men and women because you could be victimized.
The unidentified woman allegedly left with watches, diamonds, a gold chain, and bracelets, sunglasses, and a rose gold diamond ring. But this surveillance video also shows her leaving with solo cups. Cups valuable to police because they believe they could contain evidence of drugs and DNA that could be used against her.
Very sharp, obviously well trained in the trade. But what they don't seem to realize is oftentimes they're getting caught because the videos, the video cameras and
I've done this shit before.
Technologies in a lot of these condos.
She did a Cardi B.
Incidents happen, which is a good thing. Captures them and it gives a lot of good leads to law enforcement.
The woman is described as being in her mid-30s, between 5'8" and 5'10", with long black hair and about 140 pounds. If you know who she is, call Crime Stoppers at 305.
I better watch out, man. Watch out. Watch out. I think it is fake. I'm telling you. So I'd be cautious and shit, paranoid. So 56% say yes, mistrial. 43% say no, mistrial. Skeezers. I thought about that, Cheeks. I don't know. This was a nice lick. I guess I'm gonna head out of here for now. Oh, I have the tomorrow's trial set up. Okay. So I gotta go. I have to head out. I'm gonna go take the baby for a little bit. Oh man. Yeah, I heard about that missing submarine. I gotta take the baby. I gotta do a few things. We'll see how tomorrow goes. Let me see. I have it set for 8:45. The trial starts at 9. I'll be back later if there's like a chase or something. I mean, there is. I really should do the affidavit, but I don't see it happening tonight. And there's the other story too. Well, maybe we'll save it for the weekend. The Lil Wayne deposition. I might have. I'm not sure, but that could be a fun thing to watch one day. Maybe on like as an extra video. We can watch that together one day. That'd be fun. All right, love you guys. Take care. Peace. Thank you for hanging out with me today. I appreciate it. Thank you so much. Yeah, I'm gonna take care of a few things first. Unsubbed. I'm done. All right, bye guys. Love you. See you tomorrow or tonight. Later tonight, maybe. Bye. Bloop, 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 bloop. I know ice cream. It's been so nasty. I know the weather doesn't really have anything to do with ice cream, but like nasty. There's a really nice ice cream place, but my fear is that I'm going to get ice cream too. That ice cream sundae. Is it sundae? Banana split. But that's dangerous. But it's so good. A Lil Wayne deposition short. I'm going to hit you guys back up because I might have to head out for now. But I might